everyone. So today we're going to be doing an interview with Christopher Achkar, who's a very successful Toronto lawyer. He works with a lot of dentists. Now, Chris specializes in human rights law, employment law, and Chris and I have been talking for a while, and I always go to him with questions about, hey, our dentists are complaining about this or that, or they're having issues with their staff. Like, what are they supposed to do? And I thought it would be interesting to just have an interview with him and ask some questions that a lot of dentists seem to have. But it seems like a lot of dentists are really afraid to talk to lawyers. So I figured this would be a great opportunity to get to meet Chris a little bit, talk about some common problems that happen in dental offices and when it comes to employees, things that you should be putting in place into your practice to prevent, issues from happening. So yeah, I think it's going to be a great interview, and I think you guys are going to get a lot out of it. And we're going to be asking a lot of the questions that you guys submitted as well. So, stick around. So Chris, how are you this morning?
Good. Thank
Awesome.
you again for having me. I hope it's going to be an exciting discussion today.
Yeah, no, I think it's definitely going to be a very useful one. That's going to prevent a lot of problems for dentists. So, yeah, let's get into it. So, one thing that keeps coming up all the time. So, for those who don't know, like what we do with every client is we record employee calls, right? Because we want to make sure if we're going to spend money doing marketing and getting the phone to ring, we want to know like what happened, like who talked to that person, what did they call about, what happened, did they book the appointment? Now, generally, we do let employees know, like, hey, we are going to be recording the calls, because our goal is to, let them know that there is a system of accountability there. We don't want to catch the problems, we want to prevent them. And sometimes it's better if you let them know that, hey, there are people paying attention. So make sure you don't yell at the lead or the new patient calling. But one dentist asked us recently, could I record my employees without telling them if I wanted to? Now, from a technical perspective, like, yes, obviously we can do that, but I never really considered that. I mean, I don't think it's something I would recommend to do, but I'm curious from, your legal experience, your legal background, like, what do you think about that? Would you do something like that?
Sure. So the question is, you can do it because you have the capabilities of doing it, but are you allowed to do it? Mm-hmm. So generally, yes. But you have to let your employees know in advance. You cannot do it in secret. And that is exactly for quality control reasons, even safety measures sometimes. Sometimes practices may be getting calls from someone who may have certain mental health issues, or even just different safety reasons that would require you to even record. And just like you said, measuring metrics and performance of staff, leads, and these are perfectly legitimate reasons that the employer can and should consider recording. But like I said, yeah, it cannot be done in secret. There are privacy concerns. As much as it is your time that the employees are working within, there is some level of expectation of privacy that they are expecting at the workplace. So you should not do it in secret.
Okay, fair enough. Now, let me ask you this. So we had one case. Most staff that, at our clients are like fantastic people, like really great. Like we use these recordings to, improve, to do training. But we had one case come up once where the employee was told, hey, we're going to be recording calls for accountability. We want to just track how many leads we're getting and what's happening for, reporting purposes. And it came to light a few months later that a lot of those calls were not handled very well. Like the customer service, it was lacking, right? So the client was working with a coach, and, we partnered up with them. We shared the recordings. We said, I think this employee needs to work on this. And the employee turned around and said, I don't want my calls to be recorded. And I said, but I thought we were in agreement, like we were going to be doing this for this purpose. And she said, well, yes, I agreed to it, but now I don't want to do that anymore. Yeah. So I thought it was a bit of a sticky situation. What's your take on that? Does the dentist have the right to continue to record calls? Do they have to get the permission?
Well, it's always important to engage with your employees, whether it's for legal reasons or morale reasons. You want to know why this employee is having issues with not wanting to be recorded at this point, why the sudden change. Are they now going to be spending time? They realize that maybe they can't use their cell phone to do their private calls, and they'd rather do it on office lines.
Yeah.
Maybe there are other concerns that this employee may have. I don't see a reason that just throws itself at me right now why an employee may at one point be okay with it and then change their mind about it, unless they think their performance is lacking, unless they don't want, there's something there more that's definitely worth engaging in.
Okay, and asking questions, trying to get to the root of why do they feel that way?
Yes, and once you have that consent, it's generally pretty solid to say it's pretty reasonable to do it, and you've done it. So this change now, let's talk about this change, and let's pause the consent about the recording. It's important now to talk about why do you want to change, and maybe shift the conversation a little bit to root out the cause, if
right.
that were a way to put it.
Now, would you document this conversation? So if you have this conversation and let's say you dig into it further, as a dentist, should I be taking notes? Should I like make a note of that this incident happened?
Always. Notes and evidence should be done religiously. Because when and if, hopefully it doesn't happen, when litigation does happen, these are some of the most solid proof that we look for before saying, well, I can have another employee confirm that this person was toxic.
Right.
Sure, that's valuable, but it's not that valuable because that employee needs to keep their job. So I'm sure they're going to agree with the employer.
Right. Interesting. Okay.
But written documentary evidence, whether it's signed by the employee or not, is important. You have to put the date that a conversation happened, when, why, what you're going to essentially measure for next time. These are performance improvement plans to allow for how to essentially get yourself out of lack of performance or toxicity or something into a place that you don't have to monitor 24/7.
Yeah, it's really funny because like dentists are meticulous with note taking and like they document everything they do. Like their documentation practices are phenomenal, but not when it comes to legal employment matters, right? So when it comes to dental work, there's meticulous records for everything they've done, but they don't seem to apply the same sort of thinking and logic to you should be documenting every time you have an employee conversation or a performance review, right? So some do it, but what I've noticed is a lot of the younger dentists who buy a practice, they tend to inherit the staff. And sometimes they don't want to, cause ripples in the water there. Sometimes, you have employees that haven't worked with a contract for, from the last dentist. So they step in and they say, well, I don't want to cause any issues here. So let's just keep going how it's been going. Only for them to run into issues. So I'm curious.
Sorry, Nick, a lot of the recordings or documentation actually happens by mistake. So now with an age of text messaging and Facebook Messenger messaging now between employers and employees and WhatsApp and Slack, all sorts of what have you, text messages, sometimes saying to an employee something in a certain way through a text message it's a double-edged sword. While it could serve you as evidence that you've been reasonable and trying to accommodate someone, trying to work with someone to figure out something, it may not work that way if you say the wrong thing or if the employee is looking for you to say something that is not necessarily the best thing that could be interpreted and then use it against you in one way or another.
I see. So in terms of like documentation is obviously very important. What other sort of like internal policies are good for dentists to adopt so that, should you ever be in this sort of situation where there is, a bit of tension with the staff, it at least works in your favor. So you mentioned, if you're using WhatsApp, everything is logged there. Do you feel like this is a good form of communication that dentists should keep things like, sometimes you do have face-to-face meetings and maybe you'll leave notes. Is there any other sort of like good systems or processes that you feel dentists should be adopting to kind of like cover their ass essentially?
It's funny you say that. And obviously my advice changes, depends on who I'm speaking with.
Right.
From an employer perspective, I don't encourage myself using WhatsApp and all these other forms of communication that are in writing.
Mm-hmm.
I prefer those to be in person
Mm-hmm.
and for notes to be taken afterwards for multiple reasons, legal and not. And one of the most not legal reasons that these are important, things are better interpreted in person. And you can
Mm-hmm.
go a long way with figuring out a proper solution without having to resort to problems if they are done in person. But
Mm-hmm.
when things are done in person, they must be put down in a document that says this is what happened. If you can get the employee signature on what discussion happened, whether it includes a performance improvement plan in it or not,
Mm-hmm.
it's good. If they refuse to sign it, you could write down that they refused to sign it, but it was still on this date. As long as there's something we can point to and say, this is the date and this is what happened, that's better than nothing. That's certainly true. And it can save you a lot of money if things do go to litigation. Sometimes things could be quashed from the beginning if we just have the one email that is saved or the one thing that you said as an employer that shows that you really are reasonable.
Yeah.
So yeah, documentation is extremely important.
Yeah, because I've seen cases like this where most of our dentists, I say almost every one of them, is very reasonable, very down to earth. I mean, they try. It's not in their best interest to just let go of somebody because there is a lack of quality dental staff. I mean, the dental industry does not pull in the talent it once did, and there's so many dentists. They're all fighting for receptionists or treatment coordinators or assistants.
Yeah.
There aren't a lot of people out there, so they want to keep them. So a lot of them. They do work, they do spend a lot of effort trying to salvage the relationship, trying to do the training. But some of these situations, they do eventually lead to, it's just not going to work. And then I have seen it being flipped around on the dentist where the employee claims, well, you're unreasonable. This came out of nowhere. I didn't know about it. Yeah. And of course, it's completely untrue. They've spent the last 6 months trying to make things work with this person, but they don't have anything documented. It's all just conversations, right? So yeah, I guess from the court's perspective, as like, show us the proof that you have been reasonable, that you have tried, that you have made numerous efforts. And they say, well, it was all just conversations in the lunchroom. It's like, well,
it's honestly practice before even the courts have to evaluate anything, for you to just have these documents so that even the employees themselves know that you are holding down the fort, administratively speaking. And you know what is going on, and you're not being abused when it comes to certain things like overtime, or punching in and punching out at certain times, or doing things on your computer for certain periods within the day that you do not have a way to essentially not watch what your employees doing on their computers, but at least make sure they're not spending time being unproductive. It's okay to be unproductive sometimes. You just don't want to be fooled as an employer to be spending money and salaries on things that are just not working out. So yeah, it's a balance between laying down the law for the reasons that it is, for legal reasons that you need to protect yourself, but also, like you said, turnover is high. Hiring and firing themselves costs money if you want them done properly, without triggering essentially potentially lawsuits later on. So one misconception, for example, is, well, I can fire someone within the first 3 months automatically, right? I mean, the automatic answer someone could think of is yes, but that's actually not true. Unless there's a contract, that's right. Unless there's a contract that allows for a probation period for that 3 months, and to say you will be terminated within that period without being given anything, then there's no such thing as probation period. So probation period is actually a creature of the contract.
Right. And people take it for granted. They assume, oh, this is by default.
So if you look up the Employment Standards Act, you will not find that there's a probation period. There's a period that within which you can terminate someone and not pay them anything. But that is if your contract actually limits entitlements to the Employment Standards Act.
Right.
If the contract does not limit things to this legislation in front of you, then it's fair game to say that someone was terminated after 1 week and there's no probation period, and now they're entitled to, for example, example, they could say a lot of money if inducement happened.
Yeah.
Not to snowball how things could spiral out of control, but a lot of the times people like how an assistant works at a different office, for example, and says,
right,
leave your office and come work with me. If that person has been working somewhere for a certain period and you ask them to leave, bring them on without a contract, and you terminate them after 1 week, guess what? You have to essentially now pay them for the period that they've actually worked for the previous employer before you, not just the period that they were with you, because you actually brought them on board and you said, please come, here is what I'm going to offer you. Without a contract, probation periods, like I said, don't exist. And inducement, actually, not to go into bigger balls, but bigger snowballs. I'm sure that will be edited, I hope.
Yeah.
But, so let me say, inducement, one of the elements to say that we were pushed to leave from our previous employers to say, well, there was no probation period. They wanted me so bad that they said, you come on board, no contract, you're fine. So absent employment contract, an inducement argument is a lot stronger now to say. So that's just an example. I'm not speaking as a lawyer here. I'm speaking as a practical person. These are things that can practically happen. And one thing could lead to another if you have a lawyer on the other side. Now, unfortunately, people just run to a lawyer for anything and everything. When someone is advertising, call us for free, for example, or we'll take your case for free. Now people are calling for any and all reasons, and lawyers are being creative into digging into minute little details to scare employers with demand letters that, if not properly read by someone who knows what they're doing, do look intimidating. So honestly, it is safer. We said it before, before this call, an ounce of prevention is, and you
worth a pound of cure. Yeah, absolutely. This segues perfectly into, what I wanted to ask next, which is what should go into an employee contract? Because there's something that I learned from a previous lawyer years ago that kind of shocked me. So he mentioned that if you don't get that contract right, there's a lot of weird situations that can happen. For example, people often think that if you have a contract, it kind of protects the employer, and it does if it is written properly and it is actually up to date. Because there's situations that could happen where, let's say you hire an employee on a contract for, hypothetically, let's say $100,000 a year for a project, and you terminate him within the first 3 weeks. Unless that contract was drafted very clearly, you might be liable to actually paying the full remainder of the contract, even though you fired the employee. And, so this law firm that I had worked with years ago, they weren't working with lawyers, but mostly on the corporate side, they mentioned that this type of thing does happen surprisingly regularly, right? Or there might be things mentioned in that contract that either don't correlate with, I guess, the employment law, and it might invalidate your whole contract. So most people, they say, yeah, I do have a contract. Yeah. But sometimes those contracts are downloaded from the internet off of a template, right? So what should go into an employee contract? Obviously, it's a huge question, but what I want to focus on is what are critical things that, if you're a dentist, you have employee contracts, like what should you check to make sure that they're in place, or maybe you should have that looked at again? Yeah. Because there's that false sense of security. And then when it does come to litigation, they realize their contract that they signed 3-4 years ago with that staff member is completely worthless and does not help them.
It's funny now that you were saying this, I was thinking of an analogy that I never thought of before. Sometimes really downloading a contract or looking at a contract yourself and seeing that this looks good without properly reviewing it with a lawyer is like a car that looks good on the outside, but you have no idea, not if the engine is good, if it has an engine at all. Here's why. Some of the most important terms in an employment agreement are, for example, a termination clause. Mm-hmm. You can think that you've put anything and everything you want in an employment agreement and you've done a terrific job. But if you have employed someone, and we all know how time flies sometimes. So sometimes someone could start and before you know it, they've been there for 3 years or 4 years.
Yep.
the more time someone stays is a factor in deciding if and what someone is entitled to if there's no termination clause that is enforceable. So the longer someone stays, the more they're going to cost you money if that employment agreement that you have with them is not actually protected through a termination clause that limits how much you as an employer would have to pay an employee upon termination. Not just upon termination, upon even constructive dismissal allegations. So if you have an assistant who's saying, well, I was now forced to be recording my voice through these calls, and this is a big change of employment agreement for me, and that person's going to sue me, then a lot of these things will not happen, in the sense that I'll make my answer a bit clearer and edit or whatever the heck. A lot of the time, employees allege that something happened without really it happening. So if someone isn't nice with you one morning, they could say, my employer was actually being not nice. And now all of a sudden they're going and staying home and getting a doctor's note about bullying and harassment potentially, and about things that really aren't necessarily true. So without an employment agreement and a termination clause, you don't only have to terminate someone to have to pay these things, unfortunately. All has to happen is an employee may allege these things. The next thing you know, you may be on the hook without scaring people or employers about what can be alleged. I mean, not everything that is alleged or just said to have happened necessarily should be taken seriously. A lot of people allege things anytime. But anyway, if an employment agreement does not have a termination clause that minimizes entitlements upon termination, whatever kind of termination, to the Employment Standards Act, employers don't automatically have to pay Employment Standards Act. So one misconception a lot of the time people have, Nick, is, well, I hired someone and I've worked with them for 2 years and I'm going to fire them now. And I paid them 2 weeks because that's what the Employment Standards Act says. Do you have a contract with them? No. Well, then this means that person's entitlements, if they go to a lawyer, are far more than the 2 weeks. If they go to the Ministry of Labor, they're only 2 weeks, because the Ministry of Labor actually only enforces to the point that the employment standards allows for. So not more than that. So that's why it is beneficial to employees generally to go to lawyers, because they can get money exceeding Employment Standards Act.
Yeah, it's almost like there's this whole economy of trying to attract disgruntled employees. And I have seen it where there are claims that seem rather far-fetched, right? Because like I would work with some of these dentists and it's like, they're really nice, down-to-earth people. I mean, they're not micromanagers. Yeah. They're you know, like they're one of them, like wonderful people to work with. They really encourage their staff. But sometimes if, you know, let's say it comes to light that a certain staff member is not performing on the same level of somebody else. And we look at this objectively, right? So when we measure calls or results, right? I don't care who's who knows who. I mean, for me, it's data. It says employee, like a receptionist A closes 40% of new patient leads into appointments. Receptionist B closes 18%, right? Now, receptionist B might be somebody that's worked there for 20 years. They might be like a family friend, you know, and this is where it starts to ruffle some feathers, because they might feel that sense of entitlement of, I've put my time in, there's nothing wrong with me, right? And they may not be open to training, right? And then often, if it spirals out of control, that employee might allege all kinds of silly things happening that, to me, I mean, I'm not sure, but it seems really far-fetched for the dentist in question, because I know them, and like that's just not something that they would do. And these types of things can, you know, they get swept under the rug until it becomes a really huge problem. And then it can be, you know, not only the money involved in trying to settle these lawsuits, but just the stress, the headaches, the fact that you can't sit there doing dentistry, you can't focus on your business because now you have to spend all this time trying to deal with some BS, essentially, right? So This is where, like, I really strongly believe in that whole, prevent problems from happening. It is
Yeah.
way cheaper, you're going to have a lot less gray hair if you think that way of what could go wrong
Yeah.
and plan it, instead of running your business, just everything's okay for now. We'll just keep going. And then 3 years later in your
Yeah.
lawsuit, right? So now I'm curious.
Sorry, Nick. So termination clauses are a catch-all to
Right.
what could go wrong. So whether these allegations are raised or not, or whether you actually decide to terminate someone or not, having a termination clause that is enforceable will prevent from more money having to be paid. So let's say someone alleges something that's not true. We could say, let's pretend this is true. Fine, let's now look into the termination clause. Well, guess what? The termination clause says we only have to pay you X amount. So even with allegations that are absolutely false, we don't really care sometimes, and we shouldn't really care if ultimately the goal is the dollar amount is minimal at the end of the day. And termination clauses is exactly where an employer can put limiting these entitlements to the Employment Standards Act and not more.
Yeah, I mean, I guess the moral of the story here is, like, if you downloaded a contract off the internet and it sounds really good, it's like, yeah, you're looking at a car that it looks good from the outside, but you have no idea, and you might not have any idea until push comes to shove, and you actually have to pull out that contract, and you realize, like, half of what is said there doesn't actually make it. Might sometimes people download contracts where they're written for a different country. And the rules are very different, right? And then the whole thing is invalid. Now, when it comes to part-time employees, should a dentist get a contract signed with a part-time employee? Like, sometimes they will go on vacation for 2 months and they'll bring in another dentist, or they might hire, somebody to help them for a short period of time. Well, what are your thoughts on that? Would you treat them the same or differently?
Honestly, apart from being an employer myself, I'm an employer. No one is allowed, and no one should be allowed at any employer's facilities to start working without having an employment contract signed before the first day.
Mm-hmm.
The amount of detail we look into about when an employment agreement was signed versus when someone started working honestly makes a difference by the hour sometimes. If they started working for 1 day and at the end of the day they decided to sign the agreement and give it, guess what? This agreement is unenforceable. So there must be an agreement given to every single employee before they start working, whether they're part-time, whether they're contractors, whether you've agreed with them that they're contractors, but really they're employees. These things could spiral out of control if someone alleges something and then goes, whether it is to another lawyer or whether it's to the Ministry of Labor, and then says things such as, I worked overtime hours and I was not even paid for those. So things can, if not documented before an employee starts, can get messy. And even when there is an agreement between an employer and an individual, I can't really call them here an employer or contractor, let's call you a contractor and I'll pay you a certain amount of money and you invoice me. That won't necessarily fly with the Ministry of Labor if that person turns to be disgruntled in a few years or a few months and they decide to go to the Ministry of Labor. Next thing you know, you still have to justify the overtime hours that they worked or what kind of relationship you had with them. Whether you pay them invoice or not makes no difference. It's really the degree of control you have with your employee or contractor or many other things that honestly are definitely worth being put in writing well before anyone steps foot and starts working at all, so that no potential thing could happen after things go sour. When things are starting, everyone's excited.
What happens if, let's say, so a lot of our dentists, the younger ones, they'll buy an office and they really buy more than the office. They really inherit the staff.
Yeah.
And there's a lot of cases where these staff members have been working for years without any contract.
Yeah.
Right? Now, I'm not sure how it works from a legal perspective. I mean, from my perspective, it seems like they're actually buying that business, right? So how does it work? Like, if you're a young dentist, you just bought a brand new practice, the staff have been there for 10, 15 years, and a lot of them are very set in their ways because they were used to the old dentists who never really paid attention, And the biggest challenge our younger dentists have is they go in there with this enthusiasm of, we're going to revitalize this place. We're going to like renovated. It's going to be beautiful. We're going to work on our customer service. We're going to be the best dental office in town. And then they hit a wall because there's somebody there that's like, well, I don't want to do it that way. I've been doing it. Dr. Jones, who was here for 20 years, we had a good system going, blah, 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 and they don't want to change. They never had an employee contract signed with the old dentist. In some cases, the new dentist who buys the office doesn't get an employee contract signed. They start thinking about that when they realize that there's 2-3 staff members that don't have any ambition to change and they're not on board with what this dentist wants to do. They like their cushy job. They like that there hasn't been a lot of oversight. They like, and then, obviously this new dentist is coming in. We're going to track calls. We're going to do marketing. We're going to do this. And it just causes a lot of headaches. So what do you do if you buy a practice, you have staff that are there, they've never had a contract? How do you go about getting them to sign a contract, or how does that whole thing work?
Yeah, so before you buy a practice, these are the times to question what's happening. This is the time, I think, to speak with someone. Because a lot of the agreements that are out there will include what to do with staff and how to treat staff from the previous owner when you're shifting to the new owner. A lot of the times, these things are not included. And now it gets messy if the new dentist does not like the staff from the old dentist. And something happens and this employee decides to go to a lawyer. As a lawyer, what has to happen is they have to actually sue the previous dentist and the new dentist. And the new dentist.
Interesting.
Because we don't know where liability falls. Where we would know where liability falls is to look into the agreement of purchase and sale. There should be the first place that one incorporates what to do with employees. Whether they've been working for a long time or a short time, brand new, or they haven't started yet, you can always introduce a new contract with a caveat. You have to give them an added benefit in this new agreement.
Okay, interesting.
And this benefit should only be received by them if and when they sign the agreement only. You don't want the situation of them working again and you say, look, this week I will pay you under the new rate. Just sign the agreement. Just give it to me at the end of the week. Then all of a sudden they've been getting paid for something under a previous agreement all of a sudden before signing a new agreement. There's no motivation from a legal perspective, or there's no consideration to make this new agreement actually enforceable, even when signed, because that employee actually got that benefit before they even signed it.
So is it like a cash bonus, or is it a raise, or what can give me an example? What are some of these benefits? What do some dentists do? Yeah,
it could be anything and everything that is of value in a weird way.
So could it be like a $5 gift card to Starbucks? Like hypothetically, would that even be considered a?
I would, it could be. It certainly could be $100 signing bonus. It could be a $50 signing bonus. It could be an added day of vacation for the whole year. It could be. It doesn't necessarily have to be anything huge monetary. It could be 5 extra cents an hour, or I don't know. It could be in the form of prolonged monetary payment in a change of rate, or it could be any other benefit that could be given to an employee to sign this agreement. And again, I can't stress the time factor is so important here. If someone receives a benefit before signing something, this agreement is no longer useful at all. So if someone calls me and says, hey, can I have a new contract to give to this new employee to make them do X, for example, and then I work on it, and next thing I know, this person has already paid under the new rate. Now there's something else that we need to give them, whether it's $50 signing something to entice the employee to get a benefit from signing the new agreement, or else it would not be enforceable.
Okay, fair enough.
So when you are buying and selling a practice, as a purchaser, you have to look for, ideally, the previous dentist to let go of the potentially problematic people that you know are going to be problematic.
Oh, I see. So you need them to clean house for you.
You don't need it.
It's advantageous. Would it be advantageous?
Oh, absolutely, absolutely.
Yeah.
You don't want to buy a practice where you're not so sure if the employees are going to work out or not. I mean, ultimately, there's always risk when you're taking on employees, and sometimes after working 10 years for someone, things could go sour. But you want to limit how much things could go wrong with an employee. So an important factor when buying a practice is if you're looking to keep the employees or you're not looking to keep the employees.
Right.
If you're not looking to keep the employees, then you want the seller of the practice to actually terminate the employees and have to pay entitlements to these employees under or at their own accord.
Yeah, because it's almost like you're buying a liability there. And it's happened it's happened in most cases where someone buys a new practice. It's happened more often than it hasn't, where they have taken over a practice, they inherited all the staff. At first glance, everything seems great until they all start working together. And again, there's usually a big disconnect because a lot of the offices that a younger dentist will buy tend to be practices that are slowly dying out, meaning the dentist, the older dentist is retiring. I mean, he's taking things easy. It's almost like a hobby practice. And of course, the staff get used to working in a hobby practice. Then the new dentist will take it over again with these huge ambitions to actually build something wonderful. And then they'll hit the wall and then realize, oh, what do I do now, right? So I never thought about it that way, that maybe you need to make a judgment call on, do you really want to buy this office with everyone? Or do you only need some of the people? And maybe, the best way to go about it is to make sure the older dentist who's selling the office takes care of that mess so that you don't inherit that problem.
Yeah, so it's interesting because if sometimes you want to keep the people, and if you want to keep people employed under the new practice, then guess what? The old employer or the old dentist actually has to pay much less for these employees, whether they have a contract or not. But a lot of the time, a purchaser would want, and I do advise on having the seller, before selling the practice well enough to actually introduce new contracts. That limits entitlement, or that limit entitlements to the minimums, so that when the purchaser or when the seller, before they actually sell the practice, if they want to terminate people, they could actually make use of these contracts and only pay the minimum entitlements under the Employment Standards Act. So
because in a lot of these cases, what also works against these newer dentists is they've just taken out a gigantic loan to buy this office, so they're in debt. They still have school debt. They're buying a practice that has issues and they can't even fix it up because there's that block, right? So it's a little bit different if you've got $1 million in the bank. You can just say, look, I'm just going to pay you a $10,000 termination. Just leave me alone. I just want to move on with my day. Oftentimes, like these younger dentists, they can't do that. Their picture was, everything was going to work perfectly. There's not going to be any hiccups, and then it happens. So, you
can't even just terminate people by telling them here's $10,000 and just go away. A dentist must have a signed release but before they actually give the money or at the time of giving the money, so that they make sure that this employee doesn't, after receiving that $10,000, goes to the Human Rights Tribunal or goes to the Ministry of Labor or to a lawyer and say, this is what happened, now we need to sue them again. Sure, they gave me some money,
but maybe that was for overtime or whatever.
I didn't sign anything that stops me from speaking with anyone or continuing a lawsuit anyway. So a release is absolutely important when you actually want to pay someone to essentially have them go on their way.
Right.
Just giving them money will not guarantee at all that they're going to go away.
Right. Fair enough. Now, what about if an employee gets a raise or promotion? Like often what we see is office managers in the offices are, they start off as a receptionist. If they show that talent for management, for, leadership decision making, the dentist will promote from within and turn them into an office manager. Do you have to sign that contract? Is there a new contract issued? Like what would trigger reviewing the contract? Would it be raises, promotions, additional responsibilities? What goes into that?
So a simple raise that one gives year to year won't need a new employment agreement. But a promotion would, in the sense that if you're moving someone or shifting their position from a certain role to a different higher role, for example, you do want to outline the new duties. You do want to outline the new pay properly to show that these new duties are correlated with this pay. And you want to do it in a new agreement that has these termination clauses embedded in it that limit entitlements. So unfortunately, the law changes on termination clauses a lot. It's not good for anyone because it doesn't really give confidence to anyone about what is in an employment agreement. But we do know what the Supreme Court so far has said about it, and it's going to be pretty tough to say no to certain things in a termination clause. Mm-hmm. All that said, the risk is always there to make sure that once a year you do spend a couple of $100s to make sure that the contract is updated. We don't want to rock the boat every few months or every few years by introducing a new agreement, but it is a good time to look at whether for this particular person now is a good time to introduce this agreement with a promotion to then limit these liabilities as they just get accrued over time anyway. So no, a new agreement is not necessary every time with a raise, but if there are a chunk of duties that are different, that you can say this is a bit different now, and the pay is going to be, say, more than 5%, raises tend to be less, maybe not, but do gauge if you're only giving a raise to someone as part of their regular salary and bonus, or if you're actually shifting their role. And if you are, it's a good time to introduce the new duties in writing, first of all, and to clean up a little bit, administratively speaking, on what you want to give them from entitlements or not.
Yeah, I mean, it's interesting you bring this up because this actually happened to our business years ago. So we I'm sure it happens more than just dentists. Essentially, we had hired a coordinator, did a phenomenal job, and as we grew the business, she expressed interest in maybe taking over more responsibilities in terms of project management. So we had a discussion, at a coffee shop, and nothing was written down. My business partner and I at the time, we agreed to give this person a $1 raise, like, hey, you're going to have new responsibilities. So everything was great. Now, 6 months went by and a lot of projects started to fall apart. A lot of operational problems started to happen. We were very novice business owners. We didn't really know how to we were just trying to figure things out as we went. And 6 months later, we had to sort of terminate this employee. And her feeling was that, well, I never wanted this. You set me up to fail. And then from our perspective, it was well, hold on a sec. You expressed interest in wanting more. We talked to you about it on this day. From what I recall, it was the spring and we were at this cafe and we talked about this and we gave you a $1 raise and you wanted this. And she said, well, I don't remember it that way. So these things happen all the time. Again, it's at the 6 month mark, luckily we were such a small business that it wasn't worth our time to go and dispute this with a lawyer because it's what are you suing us for? We're barely making ends meet. We're a new startup, right? So, but I could just imagine if we were an established business bringing in a few $1 million a year, she would have a legitimate case because we didn't write anything down. We threw a bunch of responsibilities. It's you set me up. Her feeling was you set me up to fail. You put me in a role I wasn't ready for, I didn't want, and now you're saying, well, I didn't do a good job in this role, and now you're letting me go. And it's how would we have defended ourselves? We wouldn't have been able to. I mean, her story would have made much more sense. So I see this happening with receptionists getting promoted to office managers because the dentist feels oh, maybe she's got a knack for that. Of course, I mean, to be perfectly fair, a lot of dentists, they're not business experts themselves. So sometimes they don't notice that just because they're good at one job doesn't necessarily mean they're going to be good at the second one. things don't work out well, and then they want to let them go, right? So yeah, like I guess, you know,
Well,
what you're saying is make sure that if there is a completely different change of responsibilities, you know, and there is more than let's say a 5%, or like if there is a role change,
mhm.
you really should rethink
Yeah.
what your agreement is with this person.
Even when a lot of the times employers and dentists may think that because I have a previous agreement with someone that was drafted by a lawyer and it was done 3 months ago, I can change it now after 3 months and just change the number in it to reflect the new role. And then I'm going to write down what her position is and some of the duties. This new agreement would not be enforceable if it's not introduced properly within the timing of the salary change. And a lot of the time, these new agreements will actually have a probation clause, not a probation clause that says we can now let you go and not pay you anything, but a period that an employee is allowed to not do the best job, be trained a little bit, and actually be given a period that if they're not doing it over that period, then they're not going to succeed in this position. A lot of the promotions, employees actually ask for it.
Mm-hmm.
And sometimes when employers do give them, then that's great. But then what if the employee fails in that new role? Then we have to either bring them back to the old role, whether it's under the old agreement, that's possible, or under a new agreement that is a blend of both. And sometimes performance improvement plans are introduced to monitor and help the employee actually be successful in that new role. And these are some of the things that an employee will have to say that an employer didn't give us.
Mm-hmm.
So not every employee that said, you set me up to fail, was in fact set up to fail. Employees sometimes just don't try necessarily hard. If they got this nice promotion and if they think, okay, this is now my new role, I can get to be not really a nice person with all the other staff because now I'm the new boss in town.
I've seen that happen, absolutely.
These things need to be controlled from the get-go through performance improvement plans, whether they're an actual performance, procedurally speaking, or substantively speaking in the office, or just procedure of how things happen and carrying yourself professionally and so on. These are certainly measures and metrics that can be introduced to see if someone is being successful in their job.
Yeah, I mean, the way I look at it is I think it protects both sides in many respects, because what I have seen happen, not in dentistry, but in other professions, is somebody will be let go and they feel they have a case. And because there isn't a strong contract there, they go, you know, like you mentioned, there's a lot of law firms that will offer free consultations. And, you know, like there is an industry built around trying to find and work with disgruntled employees. But it often, like from what I have seen in my personal experience, a lot of the time it doesn't work well in the favor of the employee either. And then it's just, there's a lot of litigation that happens. There's a lot of money wasted on both sides. And ultimately, nobody is happy with the end result anyway. So if you had that contract where it says, look, it's very clear how this is going to end if it does end, and that way both parties can go their separate ways, right? But if there's always that room for, well, it didn't really work that way and this wasn't really written down, then that person can go down the employee can go down a huge rabbit hole, which again isn't, from what I've seen, it isn't always advantageous for them either. Like sometimes they spend a lot of money themselves on legal fees and get nowhere. It wastes a lot of time for the dentist too. And then their profitability and their revenue, their business really goes down because they're focused on dealing with that. And it's like nobody wins here. So I think the contract, when I look at these contracts, I look at it from, it's not just to protect me as an employer. Honestly, it is probably the best interest of my employees too, that it is very clear how things are going to split if they do split. And then we can both move on with our lives and just, you know, we both feel like, hey, we agreed to it. This is what a fair termination is. Let's just go our separate ways.
And Nick, a lot of the time, it's not necessarily what is in a contract. It's sometimes the existence of a contract or the existence of a policy or the updating of a policy. That event in itself sometimes for employees sort of shapes their day or their year in a way that the employer is on top of their work with us. Even if we do think that this employer may not be doing things right, they're on top of their work. They must have checked with someone. So that in a way does automatically, in my experience, gives some sense of confidence
Yes.
for employers, that the employees know that they're doing things properly, as opposed to just shifting them around and doing things not the proper way of doing business.
Now with COVID, right? Obviously, a lot of people have been laid off, or they've been temporarily laid off, right? So things are starting to pick up again. Funny enough, actually, we expected that during COVID, a lot of dentists would really suffer, but actually, they're all filled with their schedules are maxed out. Like, there's so many people looking for dentists. So there's a huge sort of divide. The ones that were proactive are like their biggest struggle is how to fit all the people looking to come in. The ones who weren't proactive, I mean, things haven't really kicked off, but those patients, if a practice goes under, they're going to look for a new dentist, right? Yeah. So, in terms of like bringing back employees that have been, temporarily laid off due to COVID, are there any considerations there? Like, would the contract have to go on pause? Would it be resumed? Do you note in their agreement that, like they're restarting as of this date? Like, how does that work with recalling employees? And what if you don't want to recall all employees? How does that work? Like, are you going to face any sort of legal issues where, well, why did you bring this person back but not me? But the second person might have worked there for 20 years and the first person only worked there for 1 year. The dentist feels like, well, the first person is more useful. Like, are they getting themselves into hot water by doing that? Like, give me your perspective on that. What should they consider in those situations?
Yeah, it's a tricky time for recalling employees when some businesses and some dentists may not be at capacity, or they are at capacity and they need someone, but they need them part-time, for example. Mm-hmm. So when they're not, sometimes, yes, you have to choose who to recall, how to recall. If you're going to recall everyone and apply a 10% wage reduction for everyone, or you're going to actually lay someone off or terminate one person and then only bring back the remainder of the people. Mm-hmm. The consideration of, if I do bring back these 3 people and not the 4th person, what if 1 out of the 3 people next week decides that their kids need to go to school, or they don't need to go to school and they can't work for me now? How do I recall that employee at that point?
Right.
So there are a lot of moving parts here. And the one common denominator that from just a practical perspective, is to keep an open line of communication with your employees. Mm-hmm. The more you let them know about what your plans are, the more they're going to have confidence in you bringing them back. Mm-hmm. Even if you bypass or you pass some timelines that you're not supposed to pass, employees are more forgiving when they feel that the employer is actually working with them to bring them back. Mm-hmm. In theory, yes, if you do bring back some employees, but not all, and any one of the remaining employees who has not been recalled can allege that they have been constructively dismissed. So ideally, you do want to bring everyone at the same time, or don't bring them at the same time, or make sure you have sorted out who you want to bring back and who you don't want to bring back before you bring them back.
Yeah, absolutely.
It is a time that people are happy to get back to work, and some of them are scared to get back to work. Mm-hmm. So you have to be mindful of health and safety issues that you have to do in your own practice. And I know dentists are more careful and they know what to do in terms of health and safety, or at least the hope is, but they need to stay on top of it. And they need to make sure that their employees know that they're on top of it and that they see it. They need to outline to their employees, these are the measures that we're doing to keep you keep you healthy and safe. If an employee says, well, I don't feel safe to return, it is not just subjectively that this person feels unsafe. It has to be an objective measure why this person feels unsafe. Mm-hmm. If the employee does not actually have a claim to say this is unsafe, and it's just saying it so they get to stay home for a little bit longer and get paid by EI and the CERB, for example, right, then an employer is within their rights to, and don't act on that, but potentially allege that this employee has abandoned their job. And if they have done that, then they're not entitled to anything. Mm-hmm. before you allege abandonment, make sure that they have, not just not responding to one of your calls or emails as a
Right. There's a documented list of attempts. Yeah. Okay.
These are the things where you don't want to jump the gun and say that you know what you're doing and this person has left their job because one call they did not answer you and you happen to see them driving in front of you. It may not have been them. And you can't prove that it was them, for example. So
Yeah.
a lot of these things are questionable. So before you proceed, do that carefully. But it is a time that because people are happy to get back to work, they will sign an agreement, the right agreement that is in their benefit as well.
Mm-hmm.
So it is a time to clean up house from problematic people, unfortunately, using these terms. But if there's no hope of that person working with everyone else, then they're a problematic person.
Yeah.
If that's the case, then this is the time to not bring them back. And then one would have to figure out how to structure an offer and negotiations in a way that keeps your bottom line low in that regard, and you don't just give up too much and get them to go away in exchange for a release that says they won't see you again. And for those who you are bringing back, it's hopefully one would have kept in touch with them throughout that period. If you have a fairly new employment contract, don't rock the boat, just bring them back. And then if you're not so sure about it, have a review of the contract after the fact. If these are valuable employees to you, then you may just want to bring them back and then figure out what to do. And if they're not, then introduce now what you need to introduce. And if they don't like it, then this is probably a time that one can structure a deal for an employer that is beneficial for both employers and employees, and in a way to get them to move on into their next career position.
I mean, the best advice I can give to dentists, because like you said, Chris, both of us are business owners, right? We all have employees. And one lesson that I had to learn the hard way is when you're starting out, and maybe you just have a receptionist, an assistant, and whatever, often I talk to dentists and I say, you got to put these things in place. You have to start, like, there has to be systems of accountability. You have to document things. And their response, especially among the younger crowd, is, yeah, but we're only like 2 to 3 people. Like, this is never going to, like, I don't need to worry about how this person's answering calls or what, it's a small business. And what they don't understand, and I didn't understand when I was starting a business, is the systems that you put in place that got you to where you are not going to be what it will get you to the next point. And often a lot of progress and growth stops because there's internal drama that stirs from not having clear communication about anything, the rules, expectations, agreements, anything like that. So now these days, like if I could go back in time and kind of like, set myself straight, I would have been documenting everything. I mean, to date, like the degree that we document things is, almost insane. Like every call we have with a client, we write notes about exactly what happened and what we agreed to do and what they agreed to do. And anything we talk about with employees, there's meetings that are documented. And what we found is, actually, everyone likes it. The clients love it because they know that if I ask for this, it will definitely not slip through the cracks. The employees love it because they know if I said this, I will hold myself accountable to what I've promised you. But in the past, I mean, we spent so much time going around in circles because, just like with that project manager example, 6 months went by and what she remembered and what I remember were completely different. And this spawns so many issues. So I think that younger business owners, myself included, felt that if you start being too meticulous, it's going to make it very bureaucratic. It's going to become, like very corporate. It's going to lose that culture. And I can tell you from experience, the opposite happens. That having lack of good systems and processes and documentation is what will lead to a lot of drama and bureaucracy and BS that happens. Having those systems in place, like you said, creates that confidence because people don't challenge it. They're going to think this business owner knows what they're doing. Like they're researching and they're very methodical. I'm not going to mess with that, right? So you open up the door to these problems when you are not that organized, disciplined, determined person where, no, we're going to do things by the book. We're going to do things right. to protect myself, but also to protect you, because I want to make sure if I promise you this, I will follow through, right? And it creates a strong sense of trust in that leader. And I think a lot of offices sort of miss that. So yeah, I guess the moral of the story here is document everything like religiously.
Nick,
Don't just don't just download a contract off the internet. It's not that simple. I did that, and I can tell you it didn't work well for us.
yeah, Nick, it doesn't matter that an employer is large or small. For both of our fields, for yours, if one or two of the receptionists who only do actually answer calls in a practice that is in fact only 3 or 4 people, well, that's a big percentage. If it only takes one of the people answering the phones to not do a professional job to be answering 90% of the calls or 100% of the calls, then guess what? Everyone's going to experience the same thing. From our perspective, it only needs, the law doesn't separate between a mom and pop shop and big telecom companies or big banks. An employer is an employer. So it unfortunately only takes one bad employee out of even 2 or even 1 to trigger some things that can really snowball out of control fairly quickly. So what got you here is something, as you said, and with the entrepreneurial spirit that you said it with, what got you here sure will not get you there, but what got you here is because of some things that happened. And to get there, you need to make sure that what is here is actually standing on proper foundations, or else you're not going to even get it. So if you have the wrong person from the get-go, you already have the wrong person. You need to know that in advance before you could even get to that stage.
There's this weird perception of, like we're going to keep slowly growing, but I think people don't realize the growth doesn't happen in this sort of smooth line where you just kind of keep improving things. Sometimes it happens in gigantic spurts. And something I think I read from a book where something I always stuck with me was years ago, there was an interview with, I think, one of the founders of IBM. Now he's long past. IBM's been around for a long time. They were building clocks, right? And somebody asked, even at this time when he was doing the speech, I think to like one of the Ivy League schools, somebody asked him, what is it that made IBM such a great company? And he said, well, it wasn't random. Like, we didn't just arrive here. It was planned from the beginning, and his message was, if you want to be like a large, successful business, you have to start acting like one before you become one. Okay. And, this obviously, it sounds pretty simple in practice, but you see a lot of small businesses, they don't take this mindset. If you look at a company like Apple, they didn't start off by building, a half-assed product. And then when they made a lot of money, then they started to do a good job. Like, that doesn't make any sense. You have to run your business as a 15-person organization or 20-person organization, whatever you aspire to be, when you're only 2 people, or else you'll never get there, right? Because you can't switch halfway. It's like trying to fix your car or upgrade your engine while you're in the middle of a race. It's not going to work, right? It's pretty silly. So, Chris, to sort of end it off, like, the reason we wanted to do this interview is I feel a lot of dentists are afraid to talk to lawyers. I've always found talking to you is, you're very down to earth, very easy. Like, the explanations are great. It doesn't sound like I'm talking to a lawyer. And I think,
I'll take that as a compliment at this day and age. I'll take it as a compliment.
So yeah, if our clients have issues dealing with anything employment law related, how do they get in touch with you? Like, how can they work with you?
Sure. So as you mentioned, Achkar Law, well, my last name is Achkar, so Christopher Achkar, and then our firm name is Achkar Law. They could email me at Christopher, which is my first name, at achkarlaw.com. Achkar Law is ACHKARLAW.com. Maybe we can put that somewhere. It's not a big deal. Or by phone, 647-946-6440. Maybe we can put them somewhere. It sounds like I'm giving a soundbite or too promotional, but yeah, it's this is the information.
Yeah, no, fantastic.
That was bad. We could do it again. It's just I hate.
No, I mean that's what I like about you is that I've never felt like you were trying to pitch me anything. You're really very helpful, right? So this, my feeling is we help practices grow. We get them more leads. We get the phone to ring. But the biggest challenge we always deal with is internal problems.
Yeah.
If you don't fix those, you could double, triple the amount of phone calls your office gets. You're not going to double the patient flow because there's usually internal operation issues. And when they start trying to tackle those, that's when the legal employment issues sometimes start to arise. And if they have a good foundation for, no, we've got proper agreements, like they follow all the advice that you offer, then fixing the internal things is very smooth. But sometimes you start fixing those internal problems and somebody puts up a wall and says, well, I never agreed to this. And I didn't say, you talked to me that you could record employee calls, but I actually don't remember that conversation. And we realized, well, nothing was actually signed. And then 6 months go by and then we don't make any progress, so I want to prevent these things from happening. I think it is well worth the money to have proper agreements, to talk to a lawyer. If you downloaded a contract off the internet, I think that's good enough, because I did that and I can tell you, it didn't work out well for us when we ran into issues. I think it's worth them reaching out and at least having a conversation about reviewing what they've got and seeing where that sort of exposure is, where it's like, hey, everything might go well, okay? But if it doesn't, these are potential areas where someone could actually come after you. And, I just want to get back to helping them grow their business, not dealing with litigation and drama. And I think the best way to do that is prevent it from happening.
Honestly, from a cost perspective, it makes no sense to let things burn first and then deal with it later, or even think of even allowing a spark sometimes to happen, because really cost whoever is helping, or even if you're doing it alone, the cost of time and aggravation is just too much to handle, and you might as well just avoid things before they happen as much as you can.
Absolutely. Well, Chris, thanks so much for taking the time. I mean,
My pleasure. Thank you.
Helpful. I think our dentists are going to get a lot out of this because a lot of the questions came from them.
Good. Good.
We'll definitely keep in touch and make sure that, we've been asking every dentist, do you have a proper contract? If not, you need to speak to Chris. So yeah, thanks for taking the time.
Thank you for the opportunity.